unconstitutional to prohibit interracial marriages? When did it become unconstitutional to assign children to separate schools?
Easy question, I think, for that one. At the time that the Equal Protection Clause was adopted. That's absolutely true. But don't give me a question to my question. When do you think it became unconstitutional? Has it always been unconstitutional?
When the California Supreme Court faced the decision, which it had never faced before, does excluding gay and lesbian citizens who are a class based upon their status as homosexuals, is it constitutional?
That's not when it became unconstitutional. That's when they acted in an unconstitutional manner. When did it become unconstitutional to prohibit gays from marrying?
Then they did not assign a date to a Justice Scalia, as you know. What the court decided was a case that came before.
I'm not talking about the California Supreme Court. I'm talking about your argument. You say it is now unconstitutional.
Yes.
Was it always unconstitutional?
It was constitutional when we, as a culture, determined that sexual orientation is a characteristic of individuals that they cannot control.
I see. When did that happen?
There's no specific date in time. This is an evolution.
Well, how am I supposed to know how to decide a case?
Because the case that's
can't give me a date when the Constitution changes.
Before you today, California decided, the citizens of California decided, after the California Supreme Court decided that individuals had a right to get married irrespective of their sexual orientation in California, and then the Californians decided in Proposition 8, wait a minute, we don't want those people to be able to get married.
So your case would be different if Proposition 8 was enacted into law prior to the California.
I would make that distinguishes it in one respect. But I would also make the argument, Mr. Chief Justice, that we are if marriage is a fundamental right, and we're making a classification based upon a status of individuals, which this court has repeatedly decided that gays and lesbians are defined by their status. There's no question about that.
So it would be unconstitutional even in states that did not allow civil.
We submit that. You could write a narrower.
So I want to know how long it has been unconstitutional.
I don't. When it seems to me, Justice Scalia,
it seems to me you want to be able to tell me when. Otherwise, I don't know how to decide the case.
I submit you've never required that before. When you decided that individuals, after having decided that separate but equal schools were permissible, a decision by this court, when you decided that was unconstitutional, when did that become unconstitutional?
50 years ago it was okay?
I can't answer that question, and I don't think this court has ever answered a question.
That's the problem.
What I can tell you now, the case that's before you today is whether or not California can take a class of individuals based upon their characteristics, their distinguishing characteristics, remove from them the right of privacy, liberty, association, spirituality, and identity that marriage gives them. It is not an answer to say procreation or anything of that nature, because procreation is not a part of the right to get married.
That's a broad argument that's in this case, if the court wants to reach it. The rationale of the Ninth Circuit was much more narrow. It basically said that California, which has been more generous, more open to protecting same-sex couples than almost any state in the Union, just didn't go far enough and is being penalized for not going far enough. That's a very odd rationale on which to sustain this.
This court is always looking at the context, for example, in the New Orleans case involving the gambling casinos and advertising, you look at the context of what was permitted, what was not permitted, and does that rationalization for prohibiting, in that case, the advertising, in this case, prohibiting the relationship of marriage, does it make any sense in the context of what exists?
Well, seriously, Mr. Olson, if California provides all the substantive benefits of marriage to same-sex domestic partnerships, and are you seriously arguing that if California, if the case before us now were from a state that doesn't provide any of those benefits, to same-sex couples, this case would come out differently?
No, I don't think it would come out differently because of the fundamental arguments we're making with respect to class-based distinctions with respect to a fundamental right. However, to the extent that my opponent, in the context of California, talks about child rearing or adoptions or rights of people to live together and that sort of thing, those arguments can't be made on behalf of California because California's already made a decision that gay and lesbian individuals are perfectly suitable as parents, they're perfectly suitable to adopt, they're raising 37,000 children here in California, and the expert on the other side specifically said and testified that they would be better off when their parents were allowed to get married.
I don't think you can have it both ways. Either this case is the same, this would be the same if this were Utah or Oklahoma, or it's different because it's California and California has provided all of these substances.
I think that it's not that we're arguing that those are inconsistent. If the fundamental thing is that denying gays and lesbians the right of marriage, which is fundamental under your decisions, that is unconstitutional. If the state comes forth with certain arguments, Utah might come forth with certain justifications, California might come forth with others, but the fact is that California can't make the arguments about adoption or child rearing or people living together because they've already made policy decisions, so that doesn't make them.
So it's just about the label in this case.
The label is like
same-sex couples have every other right. It's just about the label.
The label marriage means something. Even our opponents.
Sure. If you tell a child that somebody has to be their friend, I suppose you can force the child to say, "This is my friend," but it changes the definition of what it means to be a friend. And that's, it seems to me, what the supporters of Proposition 8 are saying here. All you're interested in is the label, and you insist on changing the definition of the label.
It is like you were to say you can vote, you can travel, but you may not be a citizen. There are certain labels in this country that are very, very critical. You could have said in the Loving case, you can't get married, but you can have an interracial union. Everyone would know that that was wrong. The marriage has a status, recognition, support, and if you read the
how do we know that that's the reason, or a necessary part of the reason, that we've recognized marriage as a fundamental right? You've emphasized that, and you've said, well, it's because of the emotional commitment. Maybe it is the procreative aspect that makes it a fundamental right.
But you have said that marriage is a fundamental right with respect to procreation, and at the same level, getting married, privacy. You said that in the Zablocki case, you said that in the Lawrence case, and you said it in other cases. The Skinner case, for example, marriage is put on a equal footing with the procreational aspects. And this court is the one that has said over and over again that marriage means something to the individual, the privacy, intimacy, and it is a matter of status and recognition.